Welcome to Employee Termination Tips. My name is Christopher Neufeld of Neufeld Legal, and in this particular video we'll be discussing demand letters, why they are necessary, and why all too often they prove to be ineffective. Now, a demand letter is provided by a former employee, either themselves or through their lawyer, to their former employer, stating the fact that they believe that the termination and severance pay package that they've been offered is inadequate and setting forth what they are looking for. Now, this is a necessary step in the procedural process to attain a greater payout. And oftentimes, especially with smaller employers, it does prove effective. However, oftentimes with larger employers, they take the position that demand letters are a mere formality. They receive far too many of them. And if they're going to operate off their standard position of strength and pushing back and not bending too quickly, they're simply going to refuse to offer up what is being sought in the demand letter. Yes, oftentimes they might augment the termination and severance pay package, especially if there is something intrinsically wrong with what has been offered and it's been identified by the lawyer or by the former employee. However, these augmentations very rarely are of substance, and they're grossly inadequate in most circumstances. As such, even though it's a necessary step, and judges will want to see this step having been taken as opposed to rushing immediately towards a statement of claim being filed in a lawsuit commenced against the former employer, one should not expect all too often to really receive something substantive. So one should not have their hopes built up too high in the hope that simply sending a demand letter is going to all of a sudden enlighten the employer and their legal counsel. Because one also has to understand that, especially in an era when there are mass terminations occurring, oftentimes there are tens, if not hundreds, of people being terminated. There are so many termination letters and demand letters being received that they are simply not in a position to roll over and accept what is being told to them by their former employees, knowing full well that by forcing them to pursue a lawsuit, most former employees are not going to initiate the lawsuit or not going to go very far. And yes, if a lawsuit is initiated, that is when they might start to pick up their offers with respect to augmented termination and severance pay. But it's not until the lawsuit is filed and the process is undertaken that even the lawyers get seriously into it. Because one must remember also, there are so many demand letters oftentimes that they're responding to, and employers are not in a position where they're going to spend thousands, $5,000, $10,000 of legal fees to respond to every single demand letter that they receive. Instead, they expect standardized demand responses to demand letters, and only maybe a couple hours at most being spent on each particular file until the lawsuit's filed. So with that, a lot of the responses that are going back on demand letters are not adequately researched and investigated, and the lawyers are not going to overcommit time. They're not going to be spending 4, 8, 10, 20 hours responding to your demand letter. They're going to take their standardized response back to a demand letter, probably put an hour or two, maybe get some juniors to look at it if there's something novel in there. But really, there's not much time that's being spent in responding to a demand letter. They will respond only when they're forced to respond. And that's not with the demand letter, but with the lawsuit, unfortunately. And this forces the process to augment and augment and augment and put it into a more challenging position. So you have to have that expectation of taking it to the lawsuit phase if you're serious about it. Because if you think stuff is going to get settled by demand letter, That is very rarely the case. And as I said, if there's an intrinsic mistake, if you don't have high expectations, or oftentimes when you're dealing with a smaller employer, demand letters can be satisfactory. But all too often with the larger employers, it's unlikely. Yes, there are circumstances when you can get results out of it, but that is few and far between. Most often, the response is minimal, if anything. And that's what you have to anticipate going into the process. It is necessary, but don't have too high expectations of it, because in most circumstances, demand letters are not responded to the degree that the former employer is hoping for. Thank you.